Now this is the court's ruling. What is before me is an application by the prosecution seeking to hold all the respondents, who are 13, in custody for a period of 7 days, pending investigation, and further to subject the respondents' phones to forensic examination. I have also considered the submissions by all the respondents and the prosecution. Article 49(1)(h) provides, and I quote, that an arrested person has the right to be released on bond or bail on reasonable conditions pending a charge or trial unless there are compelling reasons not to be released. Section 123A of the CPC provides, subject to Article 49(1)(h), and notwithstanding Section 123 of the CPC, in making decision on bail and bond, the court shall have regard to all the relevant circumstances, and in particular the following, and I quote: nature and seriousness of the offense; B, the character, antecedents, association, and community ties of the accused persons; C, the defendant record in respect of the fulfillment of obligations under previous grants of bail; and D, the strength of the evidence of his having committed the offense. From the above provisions of the law, it is clear that the right to bail and bond is not absolute, but it is rather subject to limitations. This further is buttressed in the case of the Republic v. Sifuna, a criminal case number 14 of 2023. The respondents have submitted that they are all civil servants, having been employed by the TSC and worked for a number of years. They have further submitted that they are not a flight risk and that they have been cooperating with the police since their arrest. The prosecution has not provided to the court evidence or proof to show that the respondents are a flight risk. I further note that the first and the 13th respondents are the deputy and the principal to the school. It is safe to say that as we speak, the school is on autopilot, with no one to steer it during this examination period. The school is a public school and therefore a public property. This court has to balance between private and public interest. The question is it in the public interest that the respondents are held in custody without bail at the risk of public property to be wasted or be stolen? What about the seriousness of the allegations in question? I note that education is the backbone of our economy as a country, and anyone who interferes or tries to interfere is akin to interfering or mess with the very fabric of our nation's development. We also have to consider the best interest of those students who are still writing their examinations. The scales of justice will tilt towards granting bail or bond terms in favor of the respondents herein based on the circumstances above. Based on the following reasons, this court orders as follows: that the respondents shall each be admitted to bond of Kenya shillings 100,000 with one surety of similar amount in the alternative cash bail of Kenya shillings 20,000. B, the respondent shall report to the investigating officer every day for a period of 14 days. From today, should they be able to post bond or bail. C, should they fail to post bond or bail, they shall be held at Yala police station for a period of 7 days. D, the respondent's cell phones shall be subjected to forensic examination and shall only be released once the IO is satisfied that they shall not be necessary to be used as exhibits. E, the first and the 13th respondent shall only be in school for purposes of administration duties and shall not oversee the examinations. F, all the respondents are barred from contacting any of the students currently undertaking their exams for the period that this matter will be under investigation. G, the remaining 11 respondents shall stay away from Nyamninia Mixed Secondary School for the period that this matter will be under investigation. This matter will be mentioned on the 25th of November 2024, so orders the court.
Your Honor, the crux of the application is that Your Honor, we do request for custodial orders for the respondents, Your Honor. For a period of 7 days to be held under the custody of the OCS, Yala Police Station.
Period of 7 days
Yes, Your Honor.
to be held at Yala Police Station.
Under the custody of the OCS. And the investigating officer who is before you.
Yes.
Your Honor, the investigation officer is investigating the offense of examination malpractice contrary to section 57 of the NEC Act of 2012.
Malpractice.
Contrary to section 27 of the Kenya National Examination Council Act number 29 of 2012, thank you.
Yes.
Your Honor, yesterday during a spot check by officials from the Kenya National Examination Council, when the
Officials
from
from
the
the
Kenya National Examination Council
yes.
and later on with the assistance of the police, did a spot check on the ongoing cases examination at Nyamninia Mixed Secondary School. Nyamninia.
Nini.
Yes, Your Honor. Nyamninia.
Yes.
And during the spot check, Your Honor, the officials noticed
Yes.
signs of malpractice, examination malpractice,
Yes.
and as a result, Your Honor, the respondents are persons of interest in the ongoing investigation. There are some material found in the classrooms, in the examination room, sorry. Some materials are found in the pockets of some of the respondents. students who are sitting. The same materials are performed.
Yes.
The same materials are believed to be copies of the examination paper and or formulas to the math paper 2 that was being
Are believed to be
so the copies of the seed examination papers.
copies of said
Examination papers
examination papers
and all formulas and answers
and
to the
or formulas
and answers to the same mathematics paper 2 that was being conducted yesterday.
Is that your holding?
No, I haven't taken something.
I thought you had
No, you are.
paper 2.
Yes,
Yes.
you are why the 7 days were there. The students are still undertaking their examinations and therefore it will take time before the statements and
You are taking the exams?
they're still undertaking the exams. And it will take time before their statements of further investigation is conducted regarding them.
Before?
I said that
You say taking the exam, it will take time before?
their statements and into the investigation with the material found is undertaken. Therefore, the IO will do it when it's a free examination day where they're not undertaking any paper. You are also reducing what you have.
Yes.
We do request for an order for forensic exploitation for their phones to be able to crack
For an order?
for forensic exploitation of their phones. To be able so that the IO can be able to narrow down to the perpetrators.
Yes. Are you through?
I am through. We are proceeding for 7 days.
I am under medication. On 27th of October, I was diagnosed with H. pylori and high blood pressure. I took the kit is supposed to take 14 days. I took the first kit, which is done, and I'm supposed to go back for the second kit and continue with medication. And because of the heart pulse rate, I was booked to go for an echo. That is in Woma.
What is it?
They're supposed to go and see the heart rate. There's a way in which
Spellings for that? Yes.
ECHO.
Like that?
Yes, Your Honor, and I want to request that you give me a reasonable bail bond.
Your Honor, I've heard the application of the prosecution.
Yes.
And first and foremost, let me be clear on behalf of the 8th respondent
Yes.
that we are objecting to the same application.
Yes.
On the grounds that the respondents being persons of interest, as indicated by the prosecution, specifically the 8th respondent, it is my belief that they are no longer in charge of examinations. And they are therefore unlikely to interfere with the investigation.
Yes.
As Your Honor stated, and I believe that all the exhibits in this case have been collected, including the phone of the 8th respondent.
Yes.
Having collected the phone of the 8th respondent, if the prosecution is allowed to hold the 8th respondent again for 7 days, it would amount to a miscarriage of justice. Put it proverbially, it would allow the prosecution to have their cake and eat it at the same time.
Yes.
You are on the issue of the free examination day. The prosecution has not indicated to court which particular free examination day is going to be, and whether the free examination day will fall within the 7 days, if at all. Well, I would wish you take judicial notice of the fact that the exams began on the 4th of November 2021, and if memory serves me correct, 2024, sorry, and if memory serves me correct, as I remember it to be, it takes 21 days. You know, simple mathematics like the paper that was in question in this particular case would mean that the exam would terminate or end on the 26th of November.
Yes, I will tell you, you're talking about math. Lawyers are known to be enemies with math.
Simple addition and subtraction, I believe.
You only become a mathematician when you are calculating your fees.
I can neither confirm nor deny.
Proceed.
Yes, it means that the exams will culminate or end on the 26th of November 2024. You are again simple mathematics. 7 days from today does not come to
Now I believe you are all teachers, you all understand English, isn't it? Yes, we proceed in English.
Your Honor,
Just a moment, let me record their presence.
As you are recording, Your Honor,
Yes.
I am present for the papers of this. I have instructions to end appearance to end this.
Yes.
I have got a sickly mad biological.
All of you have sick.
That is one of them.
You know,
So,
there's a danger of rehearsing something out of you and you.
Having high blood pressure of 150, around 150, or around 90 when it has shot up. That's messed up. And my wife, who is diabetic, I normally protect you.
unajua majukumu yako kama mtu ambaye anasimamia mwingine ambaye ako ndani ambaye anasimamia. Nitakueleza.
she's a children's hospital, and
Admitted where?
he was following us in Nyamninia hospital. Back in my house,